The next issue that's going to be addressed is, I stated in my opening statement, all the way from the city courts all the way up to the New York State Court of Appeals. So I'm sort of working down. In 2001, I was served with a complaint saying I owed money on a credit card that I hadn't paid. Totally false. They claimed I owed $1,064. And it says also, this was the complaint against me, that I refused to pay it. I owed that amount. Plaintiff rendered defendant monthly full and true accounts of the indebtedness. Never got any statements. Owing by the defendant as a result of the credit card account agreement, wherein account statements were delivered to and accepted without objection by the defendant. Absolutely a false statement. I filed a verified answer. One, I made the argument that the issue was time barred, because the last time I had that credit card was back, I think, when I was in college. So that was like 20 years before. I also made the argument that if they were sending me statements and stuff, it had to be within the last 6 years, according to what they're stating. I'm arguing I'm not the person that you're claiming to be. Claiming those money. It's somebody else. It's not me. Because I didn't have the credit card at that point. As for defendant's cross motion, the defendant has been forced to seek legal counsel. Defendant seeks summary dismissing the complaint. I also asked $500 for a frivolous action. Now, at the time I did work for an attorney. Defendant seeks summary judgment. It was notarized by the attorney I worked for. I also filed the demand of bill of particulars. I denied everything. State the date the plaintiff entered into the agreement. State the dates that the defendant was mailed copies of said statements concerning said credit card, and provide copies of all statements mailed to him. State the dates and that demands were made to the defendant to pay such bill, and provide copies of said documents. Signed by the attorney, dated April 28, 2001. Filed with the court on April 30th. In other words, this is why you want to do discovery. Judge Turner in the city of Troy rules that I filed approximately 57 days after the service of the demand of particulars. I moved for summary judgment and $500 because they never answered it. They had 30 days, I think, in which to respond. Then they filed something and it said, it would seem apparent that the defendant cannot provide any such facts or documents until he is first provided with a bill of particulars, since his defense is that he is not the person contemplated. I am not the person in the complaint, and that he has not had a credit card account in over 20 years. That was with that company. I have a credit card. He then gives them another 60 days to respond. This is now March of 2004. The other was I filed mine in April of 2001. 3 years later to get a ruling from Mr. Judge Turner. False claim. Costs. And upon frivolous claims. They had a frivolous claim. They couldn't provide anything. The court shall award to successful costs and reasonable attorney fees not exceeding $10,000. The action, claim, counterclaim, defense, or cross-claim was commenced, used, or continued in bad faith. It was continued in bad faith because for 3 years they did absolutely nothing. In the 60 days afterwards, let me flip to the next page here. Within the 60 days that he gave them afterward, now we're over 3 years later, I get a notice in the mail from the attorney, stipulation of discontinuance. And one of the arguments they made was, I didn't sign it. There's the stipulation of discontinuance. They didn't sign it either. So why would I sign something that they're refusing to sign? They want me to sign it first so they can hold it up, but they don't have to sign it? That's a bunch of bull. But this is what attorneys try to do. It was a frivolous action. Now, you noticed before he said I raised the issue, I was not the party. Person named who owed the money. I also argued the statute of limitations. With respect to the request for sanctions, this is Judge Turner ruling. The record does not support a finding of frivolous conduct by the plaintiff. Why? They couldn't produce one document. They couldn't produce the document with my name or signature on it that I applied for the credit card. It's not like today. Back in '97, we didn't have computers that do what they do today. They couldn't produce not one statement which would have had my address on it. They couldn't produce one bill that was charged to my credit card. Now, you know when you go sign, you buy something on a credit card, you sign for it, they have the little thing there for you to sign your signature. So if I owed that, they could have come up with something with my signature on it. They didn't. So rather, plaintiff's conduct appears to be no more than a good faith and wholly reasonable attempt to collect the debt. Statute of limitations is an affirmative defense to be pled and proven by defendant. Assuming that the statute of limitation had already run, it would not be frivolous for the plaintiff to bring this action on the off chance the defendant would waive the defense. With respect to the request for attorney, the defendant has not shown he has incurred an expense for attorney fees. Got an attorney sign everything. So in other words, the attorney I work for isn't allowed to make money off of my helping me with a complaint. Furthermore, defendant has not shown the plaintiff agreed to be responsible for attorney fees, nor that some statute entitles the defendant to attorney fees in this type of action. It was a frivolous lawsuit. They couldn't produce one document in over 3 years. This was signed April of 2005. This started in March. That's 4 years. That's a frivolous lawsuit. But this is how Judge Turner covers up. Now, we're going to deal with a more recent case of Judge Turner's. He's Troy City Court Judge. Now we're going to go back to City Court again. Which, again, my buddy Matt Turner. This person I know, he asked me if I could help him with his code enforcement problem. Usually I don't get involved, but he says, look, all I need you to do is do some paperwork denying it. He said also he talked to somebody in code enforcement, not in the city of Troy, but someplace else, and they told him point blank that the city of Troy code enforcement has no authority whatsoever to issue code violations because they are not certified by the state. I thought, oh, this is interesting. Why not? We made the argument to Matt Turner. Turner comes back with the response, this part shall apply to personnel who work for the Uniform Code. It further goes on to state, this part shall apply to personnel who work for local governments, code enforcement, city of Troy is a local government, counties or state agencies that administer and enforce the Uniform Code and or the Energy Code. There's a thing called the Division of Building Standards and Codes that was passed in 2010, which basically put all these local city code and everything else under the state to make sure that they're all certified. This is in 2010. This was given to me by the head of code enforcement in a different area in the state. I'll go through what an attorney told me when we get to the next part. Code. Here the code enforcement was enforcing the minimum housing standards code for residential dwellings and multi-family dwellings. Housing code. It's code. When these people show up to the house, they have on their car, their white car, code enforcement. Doesn't say housing code enforcement, it says code enforcement. It stands to reason that the code enforcement officers for the city of Troy should be certified. No, they're required to be certified under the rules and regulations set forth in 19 NYCRR 1208. Mr. French is not listed on the Department of State website as a certified code enforcement officer. The question then becomes whether Code Enforcement Officer French was authorized to issue the codes. Switch gears here. He now becomes a public citizen. He's no longer code enforcement or our housing code, because an information, a misdemeanor complaint, and a felony complaint must each specify the name of the court with which it is filed and the title of the action. The complainant may be any person having knowledge, whether personal or upon information and belief of the commission of offense Now, here you have them showing up to the house in a code enforcement vehicle. They're coming in. They're showing an ID. I'm from code enforcement. They also said he was a technician, code enforcement technician. Whether he is or not, I don't know what they call him, but he's not certified. So basically what you have is somebody that's coming in claiming to be code enforcement, coming in, all of a sudden they see something wrong. Well, is that true or not? You see something wrong. They go on writing information as a private citizen. The attorney told me that's entering the premises under false pretenses, because he's saying he's one thing and then he's acting as something else afterwards. But then again, Troy is controlled by the Democrats. Andrew Cerisi, who's now running for Supreme Court judge as a Democrat, ruled, defendant's primary contention is that the person who issued the appearance tickets, William French, was not legally authorized to do so because he was not certified as a New York State code enforcement officer pursuant to the statute. Defendant did not, however, present proof in admissible form to establish that French was not properly certified. Keep that in mind. Defendant's proof consisted of a one-page of what he purported to be a printout from a state website listing all of the certified code enforcement officers in New York State, with French's name missing from the list. A public document which may include data from a public website is admissible so long as it is authenticated, either by an attestation by the public officer having legal custody or by certification. In any event, even assuming that French was not certified, state certification was not a requirement in this case. Each of the alleged code violations was prosecuted by means of an information. That doesn't mean it can be prosecuted by any means, but they're required to be certified under the Division of Building Standards and Codes. And I've had two people tell me that besides the person that told this other person. Now, we did make one other argument that the informations weren't verified or notarized. Under the law, it states they can do it another way, which is what they did. You can put a statement there under penalty of perjury and all this stuff, and it becomes, that's considered to be notarized. He cites case law to support that, but he doesn't cite any case law saying that they don't have to be certified. Now, he says inadmissible proof. They didn't provide any admissible proof. Now, right now, this person is trying to get a copy of what was filed with the court. He couldn't find his copy. He went to the judge's chambers a couple of times. They tell him to go back to the city attorney. The city attorney says, I don't have time for this. I got too many cases. I don't know where it is. They've been putting them on. Now he's got to file a motion with the appellate court. Pay a $45 motion fee to get a document. And what the document states, they filed a reply to this. And in their reply, Mr. Foley has not contradicted any of the appellant's arguments made in his belief. That's Foley, the attorney. Secondly, Mr. Foley states, and this we quoted this so we know we have the document, we just can't find it, that Mr. French is not a state certified code enforcement officer. whether he is or is not a state certified code enforcement officer, need not be one for the purpose of issuing tickets in the present case. Mr. Foley admits that Mr. French is not a state certified code enforcement officer. French's attorney, the city of Troy, admits he's not. Why isn't that admissible proof that he's not code enforcement when they admit he's not code enforcement? This is how Cerisi covers up the case. And he wants to be a Supreme Court judge. No supporting argument for that Mr. French need not to be certified and as such should be dismissed. Now, when they went before Judge Cerisi, it was a few months after we filed the appeal to him, because from city court you have to go to county court for an appeal. Now these tickets were issued in, I think, July and August of 14. July and August of 14. That's very important. All of a sudden he gets a thing in the mail stating, a letter stating, come visit me at the courthouse. We're going to have legal arguments on this. And I'm going, why would you have legal arguments on this issue? Well, we found out when he got there. He gets up, he makes his arguments. Foley gets up, and what does he do? He has admitted into the court Mr. French's certification, stating that he is now a certified by the Division of Building Standards and Codes. Is hereby awarded the certificate signifying completion of in-service training adjustment 24 hours. Dated December 31st, 14. This is 4 months after the tickets are issued? This isn't relevant. That's why Cerisi had the hearing, was so that, now, they could have brought this in at any time in 2015 during the whole court proceedings, but they never did, because they knew it was afterwards. Because it went to an appeal, they thought, we'll stick this in. Cerisi should never have accepted it. Ask any attorney. Once you start your appeal, you cannot add anything to the appeal that was not in the original proceeding. But they did. Where's the... As soon as he came, as soon as he got down to the courthouse, he called me and rewrote a letter. This was in response to oral argument at 9 o'clock in the morning. This court should never have accepted the certification of Mr. French dated December 31st, 2014, as this was never submitted to the lower court, even though the issue of Mr. French is documented by both decisions of Mr. Turner's. Not being certified was the main argument in all of my documentation before the lower court. Certainly the city had more than enough opportunity to submit this certification. Secondly, the city of Troy is attempting to defraud both myself and the court. Now, the court's in on it, but we try to be polite. With the submission of this bogus certification of Mr. French. According to the certification, Mr. French was certified on December 31st, 2014. Tickets gives all dated August 27, 20, which is 4 months before Mr. French became certified. That the informations blank are all dated August 5, again, over 4 months being certified. The certification of Mr. French supplied to the court by the city attorney was not in effect at the time the tickets were issued. The city of Troy knows damn well that they were required to have everybody certified. They're covering it up, and you want to know why? Because all these tickets that they have issued over the years with these uncertified code enforcement officers are basically illegal. This is what the Democrats do. Judge Cerisi, covering up for the city, protect the city, not protect the citizens of the city as he's required to do by law. He's to protect everybody, their rights and everything. But no, he's only interested in protecting the city. If he's willing to fix this case, how many other cases has Judge Cerisi fixed? We even went through. They haven't provided any documentation. First, Mr. Foley fails to provide any documentation to support his argument that Mr. French does not need to be certified by the state as the only enforcing minimum housing standards code for residential dwellings and multi-height buildings. Well, where was it? I don't have it with me. They don't demonstrate any of this stuff. They just say it, we don't need it, therefore that's it. That's not true. I've talked to a code enforcement officer. I've talked to an attorney. They all agree with what we were arguing here. This is an update to Jim's motion to the appellate court, where he was looking for a copy of a letter response dated June 9th, 2015 to Judge Cerisi. That both Judge Cerisi's office and the Corporation Counsel were refusing to provide him with another copy. In fact, the judge never even sent the file to the county clerk's office where Jim would normally be able to get a copy of it. It's still, as far as we know, in the judge's chambers. We asked for the letter dated June 9th, 2015 to Judge Cerisi. Corporation Counsel sends a letter to the appellate court saying they are now enclosing a copy of a letter dated February 23rd, 2015 to Judge Turner. The court has asked me to provide. We didn't even know about that letter. We never even got that one. So they provided us with a document that we didn't even know that was sent. Plus, they're claiming this is what he asked for, when in fact he asked for the letter to Judge Cerisi dated June 9th. Not a letter dated February 23rd to Judge Turner. Jim is still waiting for a response from the appellate court on getting this letter. This clearly shows that the Corporation Counsel for the City of Troy and Judge Cerisi are covering up the illegal code enforcement citations that are informations that they are filing against people, knowing they have no authority to do so because they are not certified by the state as required. And Judge Cerisi certainly knew when he accepted that certification afterwards to have that special hearing that he had no authority to accept it. And for him to say afterwards, well, I'm not going to allow it. Of course he's not going to allow it afterwards. He got caught because of Jim filing a response the same day stating that he had no authority to accept it. And it was also a fraud being committed on the court by the Corporation Counsel. This has to end. It's got to stop what these judges are doing. They're fixing cases left and right. And you don't know what cases they're fixing. All documentation concerning Justice for New York videos can be found at justicefornewyork.com.